Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we pick up on our coverage of Florida versus Gardner and Fernandez. Now this pretrial hearing was a few days ago, so we're kind of catching up and pulling it together in our playlist for you guys. Before we start, let's just see who's in our chat. Who's with us today? Jags Girl 95. Yep, can't wait for this one. It's local, and I work for a colleague that was actually friends with this nasty Shanna. She was devastated and even made comments. It's scary when you think you know someone. Wow. Wow. Therapist, Future, and Bellatrix. Welcome to Rabbit Ears. Dreama, good to see you. Thank you so much. Yeah, so this is in Jacksonville area. Well, Jacksonville. Thus, Jags Girl. Dreama, Queen Olive Ruth Ann, Sarcasm, Meg, Zach. Who are you? Where am I? Alice, thank you for joining us. Lily Wayne. Oh. Deb H. and Carol, thank you for joining us. Traveling Teresa and Meg, you guys all made it. Dwayne. Hey, let's see. You going to pick up some Burger King? Nice. Sinbad 33, thank you for joining us. Zach. Putting your molecules back together. Fala, I have someone's right shoe. A Freudian slip and fall over. Hi again. Let's see. I joined last night when I typed my name is green when the red N, which is means new, was by my name. Now today it's back to showing my name in gray. Huh. Not sure, Alice. Not sure what's going on there. Hey, Irish Amy. Thank you for joining us. Capri Law. Awesome. Therapist, no. Thank you. Thanks for the $2, Zach. Appreciate it. No, it's actually it's a knockoff. It's an Agile. It's a semi-hollow, but it's actually an Agile. It is. I didn't purchase it. It is from a family member. So Agile guitars. Let's see. It's a house brand of Rondo Music. It's American owned since 1959. So Agile, it's Agile guitar. Or that's the make of it. Now here it says founded in 1999. So Agile. So Zach wins the what guitar is behind Squeegee today? Yeah, it's not a 335. Certainly not a Gretsch. Oh, green-eyed cat. Oh, so maybe Zach wasn't the first one. Hold on, let me go back here. Green-eyed cat. Oh, green-eyed cat. Pretty guitar. Let's see. Who did somebody else pick it out first? Who was first to say it? Joanne, Jedi Platypus, hello to you. Ah, Pammy. Pammy got it first. All right, Pammy. Oh, nope. Cajun Bayou Queen. Swapped it out again. Kestrel, good to see you. Debbie Blair. All right. It looks like Cajun Bayou Queen got it. Unless somebody else got it before, but I'm thinking Cajun Bayou Queen. All right. So for those that weren't with us earlier, it's Super Ball's birthday. She's 6 years old today. Here she is. And for those that were wondering, this thing moves. Hi. Well, hi. That's a good girl. Oh, it's a good girl. So this thing moves. You guys were wondering about that the other day. There you go. Super Ball is 6 years old today. Shaquille Oatmeal, no way. There's somebody named Shaquille. Oh, Shaquille Oatmeal. I remember you from another stream. That is one of the better handles, I have to say. That is awesome. Cajun Bayou Queen. Whoop, whoop. You got it. What guitar does Squeegee have behind him? Sinbad, when our daughter got a Mexican-made Fender, she loved it so much that we bought her the real Strat. Nice. She plays an ovation. Ovations are nice. I never had one, but a band I played with had an ovation. 12-string ovation. Sweet guitars. Yes, Cajun Bayou Queen wins. Shirley Roth saying happy birthday to Super Bowl. Mel Stiller, happy birthday, my sweet Super Bowl. Nice. Happy birthday, sweet pea. JM, I'm guessing you're talking about the and therapist, is the one that bought that. Oh, Afton Ford, what's the weight limit on that? My cat is big. Super Bowl's a big cat. She's probably at least 10 to 12 pounds. I don't know what the specs are on it, but she is in it like nonstop. I don't know why is my camera going. I don't know why my camera's going out of focus. She is on it nonstop. It's built pretty sturdily. It's pretty sturdy. Hey, Crystal, thank you for joining us. Appreciate it. So Shaquille Oatmeal. I'm sorry, man. Every time I say that, I'm gonna chuckle. JM saying happy birthday to Super Bowl. Kitten RN, I need a link for that. I have a cat that won't stay off my desk while working. Maybe therapist, do you have a link for that you can drop in, and then I'll pull it up. Deanna, what's this trial about? Okay, so Shanna Gardner. Let me pull up Miss Gardner and her. Okay, so Shanna Gardner, she's the ex-wife of Jared Bridegan. All right, let me get there. Hold on, let's see. Okay, so Shanna Gardner's the one on the far right. All right, so Shanna Gardner's far right, this way. Shanna Gardner's far right, obviously, because she's the only female there. So she was married to Jared, right? And now she's married. Jared is the guy with the little baby right above my head. That's Jared. And then Mario is the guy in the green, right? So they're accused. So Shanna and Mario are accused of orchestrating a murder for hire that Jared was shot. Jared was shot in February of 2022. And this was in Jacksonville Beach. So he dropped off his twins, who he and Gardner had together, right? Authorities believe the killing was carefully planned, and both Gardner and Fernandez, so that's Mario, they were charged with first-degree conspiracy and solicitation. The shooter now, here's where it gets interesting. The shooter is Henry Tenon. He pled guilty, right? And he initially claimed he was hired by Mario and Shanna, but he later said parts of his testimony were false. So then the court approved the release of his jail phone records. So we got to find that at some point. We'll play that. So the trial is set to begin in October of this year. And she is, I know the last time we did, her family is part of something huge. You guys help me, what's her family? Shanna Gardner. Oh, and Jose Baez is repping her, and he was, oh my God, what is her name? Who did Jose Baez represent? It's right on the tip of my tongue. And then in Florida with the mother and the girl, the little baby. Drawing a complete blank because I'm thinking about 20 other things. Somebody in chat, please help me. Jose Baez. Casey Anthony, thank you. Yep. Not Jodi Arias, Casey Anthony. Casey Anthony. Thank you, guys. Casey and Kaylee Anthony. Yep. So Jose Baez represented Casey Anthony. Yep. Casey Anthony. Thank you, guys. Thank you. And so he used to work at Microsoft. He was an executive for Microsoft, Jared. And her parents are like, is it like a candy? Oh no, it's like crafts. They're like something with crafts, right? Yeah, Juan Martinez was Jodi. Now he's the prosecutor, and then Kirk Nurmi was the defense for Jodi. Here it is. Shanna Gardner's family money. It's some kind of crafts, right? What are her? She comes from money, and it's something to do with crafts. You guys, craft place Yeah, craft place, something like that, right? It's something I may have it in one of my notes, but I don't have it handy. Let me see. Arts and farts? No. Um, she comes from money and it's something to do with scrapbooking. Is that what it is? Stamping Up? Stamping Up? Is that what it is? Okay. Yep. Stamping Up. Okay, so yep, this is what they do. This is where she comes. Ways to craft. So this is what she does, or her family comes from this. So that's why they have money um, to hire Jose Baez. So it was founded in 1988 by two sisters. Stampin' Up has provided high quality papercraft products. Now, is that her grandparents or her parents? Oh, probably her grandparents. So Sarah Douglas, so founded by Sheila Gardner, who appointed her daughter Sarah Douglas to be CEO. That was in 2016. So that's not Shanna. That's Sarah. All right. So they are in United States. They're in Canada, Australia, New Zealand, Germany, France, UK, Australia, Netherlands, Ireland, and Belgium. So they're like all over the place. Oh yeah. And yep, you're right. Yep, he did Aaron Hernandez as well, Debbie. Thank you. Stampin' Up is the company. Yep. Stampin' Up. Stampin' Up. Yep. So so they come from money. That's why she can afford Jose Baez. Okay. So that's kind of the backstory. Now, this judge is fantastic. If you guys don't know this judge, she's London Kite. She is a badass. You guys are going to love her. If you watch the previous hearing, she is just spectacular. Her middle name is Mahogany. You got me right there. Judge London Mahogany Kite. She is fantastic. Let me give you a little bit of backstory on her. She spent 17 years as a prosecutor in the Fourth Judicial Circuit. She was elevated to circuit court bench in September. The governor appointed her county court judge in July of 2020. Then she got bounced up to circuit court. She describes herself as a workaholic who is firm, fair, and full-time. She's committed to justice. I expect lawyers to be as fully prepared and present as I am. She's a former middle school teacher, right, and an adjunct law professor. You'll see with these two sides fighting and bickering, you'll see where the middle school teaching comes in. She was great. The last pretrial hearing, she was great. She is a loving wife and mother. She's hold on. She used to be a former cheerleader for the Tampa Bay Buccaneers. I just love that. All right, so she's a middle school teacher, ex NFL cheerleader. Judge Kite is bad to the bone. I love her. She's fantastic. All right, let's get to it. Oh, and the reason you'll see Shanna comes in street clothes, Mario comes in prison garb, if you will. That's their right. They can dress however they want, even though there's no jury, because this happened the last pretrial. Yeah, we've seen her before in street clothes, and people were asking why is she in street clothes. That's her right, even though there's no jury. I think it's more like, it's for the cameras, in my opinion. So it is Afton. Yep, this was Tuesday. Yep. So we're just catching up. This is Tuesday. Okay. Yeah, the title April 8th. Last time I checked, today was the 11th. So yeah, so we want to collect this into our playlist because we were covering Monica on Tuesday and then Lori Vallow. So we just want to, now that we have time, Monica's over, Lori's nothing for today. So we're just making sure we get our playlist, as full as possible. And Ann just says, happy birthday to you. She said, thank you. I'm going with that, Debbie. I think so too. I think she knows the cameras are on her. All right, let's get to it. Okay. Judge London Kite is fantastic. You guys are going to love her.
Good morning. Thank you. All right. I want to apologize for the delay. So we are here. The defense has filed several motions. I have an order designating these cases as priority cases. I have copies for the attorneys. Can you staple these? I understand that the state was going to start an index.
Yes, Your Honor.
All right. Do you want to tell me what the status of that is?
Your Honor, I was in a week-long trial last week. I did meet with my paralegal yesterday. Our paralegal has been designated to work solely, not exclusively, but mainly on this case. He's begun indexing discovery. He's indexed about 4,500 pages of discovery thus far. He also has been working on the joint motion to compel discovery, which was filed by defendant Fernandez and adopted by defendant Gardner, and we are beginning a written response and provision of some of these things that are missing. Some of the items on this are not items that are missing, but questions the state can answer, and I'll do so in a written response. Detective Padilla with the Secret Service and Jacksonville Sheriff's Office Computer Forensic Investigations Unit has begun the process of, other than the defendant's devices, all other devices in the case, reviewing the original data to ensure the data is complete in hash valuing all of the devices so that we can provide a file size and hash value for each device to defense counsel to ensure that everybody has the same data that they're working from. So I believe Gardner's team filed a motion to compel electronic discovery. So that's underway with Detective Padilla.
Is there any objection to that?
Only to the time frame. They requested that we provide that within 30 days. I've spoken with Detective Padilla just because it takes time to rerun the data. I don't know if that's realistic for us to complete it. So I would be requesting, I have no objection to it, but I'd be requesting a window of 60 days. And if we run into any issues, that we'd be allowed to come back before the court and request an extension on some of the devices.
All right. So, how is this index going to work with the request for the specific discovery? It's over 100.
So I've looked through this and my paralegals looked through it, and I have notes on every single item here. Some things I need to follow up and request from Jacksonville Beach Police. There's some surveillance videos in the property room that were negative evidence that I don't have. I would just, probably what's most prudent is I just file a written response to this in addition to the index.
What about the items where it says that it doesn't work? Like whatever you all have provided doesn't open for them,
Right.
It's in the wrong file format.
So there were a couple that I had my paralegal check himself. We were able to open them. I think it's best if I file a written response specifically citing to that number, just outlining for defense counsel how to open the items.
I'll give you an example. Like I believe it's ATF PowerPoint. where it says that you all provided it in a PDF and there is no ability for the defense to open that. I'll give you that as an example. Like, how is a written response going to solve that?
Right, specifically, item number 5, ATF cell data location, that's actually FBI cell data location. There's a PDF of the PowerPoint. I will provide them a color copy of the PowerPoint. My response would be, there's no animation. I don't know what they're speaking about. So my written response would be, I will re-provide the PowerPoint in a color copy. I can do it instead of scanning a PDF to them, actually provide it to them. But when I email them the slides, I email them the slides as I receive them. The animation doesn't animate. There's color coding on the map that a color copy might assist them better.
All right, what's the defense position? Have you all met since this time?
As far
You can remain seated.
as far as myself and Ms. Day and Mr. Dreiser, for you,
Right. I thought also, Mr. Khalil, you might have said that you all were going to talk to the defense about the index. Am I not remembering that correctly?
Your Honor, where we were left was we're waiting for the defense to file a motion to compel. We have a discovery conference scheduled next Thursday, where hopefully a lot of this will be outlined as to what they're going through. I think the intent was to do what was requested of the defense, which is to indicate in this index where the files or the information was previously tendered and in what format, so that they can easily cross-reference from the original responses.
All right. You all said that your discovery meeting is next Thursday?
Yeah, yes, Your Honor, we have a conference scheduled at 4 p.m. on Thursday the 17th.
And some of,
Judge, and I think from my perspective at least, having spent about a day and a half since our last court date going back through everything, from Ms. Gardner's standpoint, I need the index. I think a big problem here, going back through it cradle to grave, is that the state initially started listing every subpoena by date, and then they moved to generalities like toll records. Well, it's hard for me to know when I've got 6 different types of toll records for a certain individual, and I'm missing subpoenas for some of them, how that all matches up. And so I really, from Ms. Gardner's perspective, I'm really looking forward to the index so that I can cross-reference it with what I have, as I told the court last time, that I have and Ms. Gardner's team have sort of indexed and created our own sorting system to match it up and see what the state has on its end. And I have reviewed Ms. Day's detailed motion that she filed, and I agree with everything she said in there. That cross-references with our own list of concerns.
And from Mr. Fernandez's perspective, Your Honor, we echo those thoughts, as well as would like to just address, and at the discovery conference, we can kind of get into the nitty-gritty. Today's probably not an effective use of time, but from the one specific example that the court asked this morning, the state responded that they would give us a printout and that would resolve it, but we just pulled it up again, and when you pull up the PowerPoint, there's a play button. We can't play it. So I don't know how giving us a colored copy I don't know what would play if it could play, and maybe their response is it doesn't play anything, and then we can look at theirs. But that, just to give you an example, that is what we're seeing, is that there's a play button. It looks like there's an animation of cell data, and we can't see that.
Okay. All right, so based on the motion to compel the responses, I think that, and like I've outlined in this order, which is pursuant to the rules, it's just a part of how this court normally presides over cases. However, I've given kind of like a more leeway, and I have not been as involved in the progress of these discovery issues, and it is what I have detailed, which is none of these issues are new. They have been there since the beginning. I know that the parties, which I've also detailed, that y'all have been working diligently, doing depositions of witnesses and things of that nature. However, there are a couple of things that I can see, at least from what the defense has filed and what the state's position is. The issues are lost in translation somehow. And I don't know, like if they say they can't open it and then the state's response is we'll just reprint it, that has been the issue. And it's also the subject of another defense motion, which is the duplicative nature of such a large amount of evidence. And that is what I want to avoid, okay? So this is what I'm going to do. You all have a meeting already scheduled on April 17th. You all should conduct that meeting, okay? And to the extent that you all can go through essentially each line item, that is the defense saying whether it's Ms. Day indicating that you don't have it, and then the state with your paralegal or whatever you're doing, that then you either have it or you don't have it. You all come back to the court, and I want basically a call down list of things that you all are not able to resolve from this discovery meeting. Does that make sense? So you all are meeting. You can say, we were able to resolve, and y'all keep working essentially from this document that has been prepared, that's been adopted. Are y'all with me? So if you all are able to resolve and the state has provided, then you all, in a discovery response, outline that. You all let me know what is still outstanding and what is not. That is a state disclosing, referencing the motion to compel by line item 27, whatever. You all have now resolved those issues, okay? So from the 17th, I'm going to give you all a week. That is all of the week of April 21st, okay? And then, if you all have the time, we are going to sit down and have a hearing. I would propose May 2nd. And is the defense okay with the state's timeline on providing the electronic evidence? Y'all want it in 30 days, correct?
Judge, we want it as fast as possible. So
Right.
whatever the court, as much time as the court wants to give the state. We'll defer to the court.
Before I hear that motion, if the state wants to be heard on a different timeline than is requested, then I'll set that issue for a hearing. You can call whoever that can explain what's going on to me, and then I'll make the decision. Okay? But that will be before the 17th, so that that person can be working, or, so when are y'all available? I would propose on this motion to compel, we would handle on May 2nd. The issue related to the disclosure of the electronic evidence, I could do it this week. Whenever, if you want a moment to
Judge,
try to contact your,
I'm unavailable the remainder of the week.
okay, no one from your firm is?
This, depending on the day, Your Honor, this week, I can be available. Wednesday or Thursday, but that's tomorrow.
Would the state like an opportunity to contact the witness?
Yes.
See when he's available? He can, as far as I'm concerned, and what I try to communicate in this order is that I'm going to make this case a priority to resolve these issues as quickly as possible. I don't want weeks to go by, because if I let that time frame go by, that could be time that people could be working and they know what deadlines are. Per the discovery rules, I'm going to set deadlines. I'm going to issue orders, and those will be complied with, or you all can ask for extensions. And the attorneys will also make this case a priority. There is a rule that allows and mandates what calendar conflicts look like for the lawyers. The factors listed, which I put it, all these are just rules. I know y'all have filed all these motions, but these are rules that we should all just observe, right? If there are calendar conflicts, if there are schedule conflicts, they should be resolved in favor of this case being moved forward, because there are too many witnesses, there's too much evidence, there's too many issues overall. So if it's a smaller issue, I'd ask for some member of y'all's firm to be available, some member from the state to resolve these issues, and so we can move forward. I don't need everybody. Y'all can designate one to handle this court's ruling on how long it's going to take for this person to hash value, whatever you called it, like say how big certain files are. I'm going to listen, I'll make a ruling, okay? So somebody, small issues, I don't need everybody. I would like for the attorneys, especially on the defense side, like Ms. Day, for you to be available. Ms. Medina, if she's, I think she's on, to help Ms. Peoples, if y'all are like dividing work that way, so that we can move these issues forward. The other thing I wanted to ask the lawyers about is that I think probably the like November timeframe, I brought up to the lawyers that I'm assuming, and I know that the defense has started filing some of the capital motions, but I did not see really any indication or designation by the state of witnesses that would be related to the penalty phase.
Your Honor, I'll just speak to the believe with the aggravators that have been enumerated, it's all contained within the facts of the underlying work.
Understood. But I also, like, if there are any disclosures related to, like, for example, this is all hypothetical. So let's say the state maybe anticipates adding further information, such as like a medical examiner that would testify even, so let's say it was HAC. That is not the case here, right? I would ask that the state be very specific, okay, about witnesses that may carry over, that may offer additional evidence that would be admissible kind of only in the penalty phase. Like, so you can put your straight evidence on in the guilt phase, but let's say, like, if it was HAC, maybe the medical examiner for prejudice reasons would not testify about the pain, the suffering, all of those things in the guilt, but they then are elaborated on in the penalty phase. So if there is a witness that would expand on information related to the penalty phase, then I think you should put the defense on notice. Additionally, if the state has done any mitigating investigation, the rules call for disclosure of that information to the defense. And I don't want it, I want it made big and bold, capital discovery, penalty phase discovery, so that we don't have any issues related to what has been brought up in the past. Like, I think Mr. Dreiser is the one that brought it up. He objected to how, like, a transcript was disclosed by the state. It needs to be, I would like for the state, as best you can, because the discovery rules not only say trial, but this trial has two parts, that you also disclose what you would potentially offer in a penalty phase. Maybe it's nothing, but I asked for that a long time ago. They have started filing their motions for them to then file additional motions that if they want to object, I'd like to handle those early on. Does that make sense?
Yes, sure.
Okay. So, let's talk about the trial date. Does anybody think it's realistic?
No, Your Honor, I think we've had discussions off the record about moving the trial date, and I think we at least had preliminary discussions about the selection of a new trial date. I've spoken with the next of kin in this case, and they are understanding and in agreement with the new trial date that we had previously proposed.
What about the defense?
I would, I'm having Ms. Gardner concur with the state's assessment.
On behalf of Mr. Fernandez, I concur with most of what the state's assessment is, but would take the position, however unfavorable with your newest order, that until we see this newly organized discovery, it's premature to set the trial date.
All right.
Judge, if I could just go back for a second on the discovery, the joint motion to compel discovery. And I think the state, what I'm trying to understand, is the state to file a written response before the court expects us to meet and confer, or after? I would prefer they file something before, so I know going into the meeting what their position is on each line item, as opposed to going in there and not having an idea of what their position is, or to the extent not having confidence that they have looked at all 207 items. Because otherwise it's going to be a waste of time and take us a long time if we're saying, hey, okay, let's talk about item number 203, and they haven't even considered item 203. So I just want some assurance before, and I think a written response is appropriate before we dedicate the time and resources to go have this meeting, that the state has looked at each of these, formed a position on each of them, and then we can go in and we can talk about the position and maybe transfer items or have them show us how we can open things or whatever it may be. But my concern is that 1 week from now is a short time, for in my opinion, unless they're going to dedicate the resources to it, to get through 207 items and get a response to us or have an idea of what their position is on all 207 items.
The paralegal that y'all have working on it, how far along?
We've looked at each item on this list and at least have started. I have notations. I'm not ready to provide my notes to defense counsel today, but some things I'm ready to provide, some things I'm looking to find, and some things are, many of these are questions that don't involve provision of a missing item, but something I need to answer for them. Like how to open a Google, you have to use Notepad, that sort of thing. My concern is I don't want to file a written response until I'm certain the response to each item is what it is, if that makes sense. Because I don't want defense counsel taking what I provide to them, which they tend to do, in an email or a phone conversation and putting it in a motion later. Because I'm trying to provide it, information changes, it's fluid. I don't want to make a written formal response, sign it by the state saying this item doesn't exist because I'm looking at it now and I can't find it, but later I find it, and then it shows up in some motion. I'm doing my best to assist them, and when I send emails and provide these items, it's in an effort to assist as quickly as possible. But in terms of filing a formal written response, I prefer it to be more accurate than expedient. But I'm happy to provide them information in an email, understanding that it's not the state's final written response before the discovery conference, and then supplement it with our actual formalized, corrected to the best of my knowledge response after our meeting.
And that's the problem, Judge, is that we never get finality with them. It's a moving target the whole time with this discovery. And so what we're trying to do, and what I thought the court's intent was, is that everyone is going to get locked in. Here are the issues. They're going to provide us a final response, and then we proceed forward. We cannot proceed forward if this is a continuous moving target. And that's what Ms. Stifler just told the court.
That's not what I
That it's a
said.
moving target.
I'm happy to
Well-
respond in writing. I just am not prepared to do it until we discuss some of these things at the discovery meeting.
What was, I understand. So let's say we never had this court date, right? Y'all had already scheduled this discovery meeting. What was the understanding? Because at the last court date, y'all said that you had the discovery meeting, I guess scheduled, and I was coming in before it, and I asked because that the defense formalize not in an email, which y'all did, and you did it within the time frame that this court asked. But this discovery meeting was always going to take place.
So Judge, the discovery meeting was something that Mr. Khalil proposed in his letter that was going to essentially hit reset on the discovery process.
And I did ask Ms. Day to, and I'm sorry to interrupt, also, I asked Ms. Day these items that we've been going back and forth via email to number them, so that the discovery meeting, we could discuss them in reference to a specific number, and I could provide that information and then give them a written response to some of these items. So I'm not saying I'm not willing to do it. I'm prepared to do it. I just can't do it before this meeting because some things maybe we can work out that would clarify the response that I would put into writing. In terms of, I can't open this item, I don't have the correct application, that might be something, or they're asking for things and they're citing at A3, I need clarification on where they're citing to before I can respond properly. So I'm happy to respond formally in writing, and I'm happy to give them an idea, or speak with them, or give them notes, or an email of my initial review of this, but I'm not prepared to file a formal response prior to following up with them about some clarification issues I have in order to respond.
And Judge, we'll speak to the state. We have no problem meeting with the state. My concern is if the court's expectation is that we're going to sit down with them in a week and go through all 207 items one by one, that without us having a preview of what their position is, that's not, in our opinion, not workable.
How long is this meeting initially set for?
I think it's at 4 o'clock at the end of the day, so I would anticipate, 30 minutes, an hour, is what we envisioned on our end. It was never meant to be a sit down and go through 207 line items.
What was it meant to be?
I think just an update as to where we are on Mr. Khalil's endeavor to reset discovery.
Why do y'all need to do that?
Judge, the idea behind it was to have regular discovery meetings monthly so that we could address not necessarily all 200 items at one meeting, but at least make attempts to go through and resolve every issue defense has. And knowing that we all have a specifically allocated time period every month to do so in order to keep track of all the requests in one place at one time with all parties present. This was just the inaugural meeting.
That seems like a waste of time. What is the most important thing that's going to move this forward on this list that y'all want an answer to?
All of it, Judge? I don't know. I don't know what the court means by move forward.
Meaning, so I'm assuming, maybe wrongly, that y'all still have depositions moving forward.
We don't have anything scheduled because.
Why not?
Because we have taken, I believe, most, if not all, of the civilian witnesses and several or many law enforcement witnesses, but we are now to the detectives and the agents that really participated in this, and I don't have confidence that I know every subpoena that was sent out and the return, that we have all the reports and their attachments. I just don't have confidence, and what I don't want to do is start a deposition, and that's sort of why we wanted the deposition of Detective Johns, is to go through many of the items that were on the list, and we did set aside a full day for that, to go through the items on the list and ask, for example, we have a return from AT&T for this number, but we have no associated subpoena. Where's the subpoena? We have a subpoena, but we have no associated return. What happened? We're missing the attachment to this police report. We have sub-reports through 164. Are there any more? Things of that nature. And most of that, if not all of it, has been, through great effort of Ms. Day, memorialized in this document.
All right, so at least at looking at this list, generally speaking, it looks like from the reports, I'm assuming, because looking at this list, there appears to be maybe one Jack's Beach report that appears to have some issue with it, that there's maybe part of it. There are computer forensic reports that I guess aren't working, and some forensic reports from Jack's Beach that are related to the electronic evidence, and the other part are ATF reports. I think just a glance at this, that a lot of maybe some of the issue would be that because the defense is missing, for example, an ATF report, the ATF report would let them know that whatever subpoena went out, did not come back any type of return. It would be contained potentially in the narrative of those reports. And so the fact that the state has listed it because it somehow appears somewhere, but then the report would then answer the question. I think that you all start with the reports, that they cannot compel. Only the state can get unredacted copies of some of this information so that they can read it and maybe cross-reference that this isn't some mystery. I think a lot of it is because they don't have full access to some of these reports. And what is this like online thing that they're referencing?
I'm sorry.
So are you talking about number 3?
Right, what is that?
So we found that on a public available website that was released by the state in a public records request. Much of the content we have, it's a different format than it was provided to us by the state. And there's a cover letter from the ATF that neatly organizes these reports. It was released by the state at some point via public records to the media, and now it is posted online. And it's this nice 250-page binder of collated ATF reports that was never provided in that format to the defense.
Do you know what they're talking about?
I don't know how the formatting issue, but I've looked into it and I can provide, that's ready to go, provide to them in that format now.
In the format that is online, but unredacted?
Yes.
Okay. How many total supplement reports are from Jack's Beach?
One moment, Your Honor. I'd have to look that up.
And has the state compelled all federal agents that worked on this case to get their work product? And are they willing to release it kind of unredacted for the defense disclosure?
Yes, they have not given me any issues releasing information to me. I do have a Zoom meeting with our analyst with ATF Friday to collect the entirety of her work.
What about Secret Service?
Secret Service was only involved in the extraction of the devices. Those reports are in the files provided with the devices themselves. The same way that JSO puts their mobile device extraction reports and receipts in their Celebrate folder, so does U.S. Secret Service.
What is a receipt?
That's their version of the chain of custody property card showing that they received an item. So, for example, that would be something I would respond in writing, that receipt is referring to this document. They call it a receipt. We colloquially would call it a property card or a chain of custody card or receipt of property card.
Are you all still using evidence.com?
Jack's Beach, that is their case management
No, I
system.
mean, is that how y'all are
No, ma'am.
getting the okay, well, what are y'all doing?
In regards to this specific request, I'm going to file a written response and attach
No,
it.
I mean, how are you, like, example, like, so you are trying to give them these federal reports. How is that being delivered to the defense?
That's something I want to discuss with them at our discovery meeting, because I have them prepared. They can advise me how best to receive them. If they want me to open new files on evidence.com with an audit trail, if they want it on a hard drive, a disk, the physical document portion of the response, I'm just going to attach and scan in with the discovery response so that it's attached to the discovery response and clear.
What's the state position on, I guess, the appointment or deposition of Detective Johns? Are y'all still objecting to that?
To him being under oath and subject to questioning, I had told Mr. Carody and Mr. Hill in a phone conference that I had no problem having them come to Jacksonville Beach, sitting down with a property clerk or myself, my paralegal, and having Detective Johns available to answer questions or provide items as necessary. But again, my concern becomes when we're trying to answer discovery responses, that they're taking sworn testimony from him on, as we're trying to resolve issues that they're going to put later in a motion or a filing.
And Judge, again, that's the finality problem, is we're trying to move forward, lock the state in on what their discovery is for a case that they've been working now for more than 3 years, and they're still not willing to let their lead detective sit down with us, and if we ask him if something exists, let him be bound by that statement. And that's you know, that goes to the discovery here, where you're never going to move forward until we're able to lock the state in. And we have, Your Honor, just to let you know, we have, at least from our position, we know that we have up to SUP 167 of the Jacksonville Beach Police Department reports. That report is dated September 11th of 2024. That is the last Jacks Beach Police report we have.
Hold on, give me the date again.
9/11/2024, SUP 167.
Let me ask the defense, Ms. Day, Ms. Medina, or Mr. Cody, the subpoenas that are referenced in that list, none of those answers are resolved in the reports that have been generated by Jacks Beach?
Correct.
So Jacks Beach is indicating that they've sent a subpoena and there is no resolution by narrative that there will result or no result.
Yes, but I would also say oftentimes the Jacks Beach reports themselves don't even indicate that a subpoena was sent. We're just finding subpoenas.
How?
Many were sent, they were all issued by the state, right? The state issued them. Some were sent by ATF, some were sent by Jacks Beach PD, some were documented in reports, some weren't, some we have returns, we have no subpoenas, some we have subpoenas, we have no returns, and I think that's a fair assessment of what we're looking at. I've been through this in detail recently, trying to figure out again where we are, and the state's first discovery exhibit, if you pull it up, Judge, they did a beautiful job of saying, here's the date that it was, there are some errors in that, but they did a beautiful job, listing the date the subpoena went out and who it went to. The problem is that was really the first year of subpoenas, and they have sent dozens and dozens out that are not listed in any discovery exhibit with that type of detail. And that's why we're looking forward to the index, to try and cross-reference to what we have identified.
What is the state's position on a deadline of this Friday to give the federal reports and determine from Jacks Beach if there are any reports past 167?
Are you referring to specific numbers or just in general any ATF and or Jacks Beach police?
So from you said that that is ready to go, so I don't necessarily think Friday is unreasonable deadline to basically produce this unredacted report that has been prepared through public
I
records.
can specifically tell defense in the court, I am fine by Friday to provide items 3, 4. Item 5, I just confirmed with Agent Bobby Blythe with FBI, there are no animations on these slides.
Why does it have a play button then?
I don't see, I'd have to speak with Ms. Day, but I'm looking
Show
at
it
the
to her,
slides and I don't see a play
stop.
button anyway.
Just show her what
Put it
you're
on the
seeing.
screen, Judge, so we can all see it? I mean, okay.
I don't know, whatever she wants.
Well, it's,
I don't know. Yes, put it on the screen, I'd like to see it. Hook the computer into that thing. Go to the cart.
The record I'm being told, that's the ATF work, analyst work product slide. I don't know what that means, I think we should get it if it exists. Because if it's work product that they intend to use, which I would imagine that's a real possibility. And even if they're not, we need
That's
a
fine.
response to that,
Mr.
so.
Dreiser, I'll provide it. I just didn't realize that's what they were referring to. That's where, see, this is where some of the confusion is coming in. That was a slide provided to Mr. Dreiser and Mr. Hill at a meeting many months ago.
Has it ever made it to a disclosure?
No, because it was being prepared for trial purposes as a demonstrative exhibit, but I will provide it. That is the analyst that I said I have a Zoom meeting Friday with to get all her work product. I will provide that after I meet with her Friday. But
That's a PowerPoint. What number is that, Ms. Day?
What number in the motion?
Right?
It is,
number 5.
yes, number 5.
I can't have that by Friday, because I have a Zoom meeting with her Friday afternoon, but I can provide that after.
All right.
I can provide item 6. I can answer question 7. I can provide item 8. Items 9 through 14 are going to be on hold because I think they correspond to the electronic evidence. And as I told the court, I'll have the detective come lay a foundation for the state's request for an extension on the provision of those items. Item 15, 16, 17, and 18, I can answer those questions by Friday. Item 19, I can answer that question by Friday. Item 20, I can provide by Friday.
Hold on. 15 through 17.
I'm sorry, 15, 16, 17. Yes, ma'am, I can answer those questions by Friday.
All right.
18, 19, and 20 are questions I can answer by Friday. 15 through 20 is just a clarification as to how things are categorized and labeled.
I can barely hear you, Ms. Stifler. You said what number?
Items 15 through 19. They're just confirmation and/or clarification by the state. For example, number 18, photos of clothing refers to the 10 photos. Item 17 had been labeled JO DNA consent form.
Hold on. So, does 18, these photographs, how does Jack's Beach categorize those? Do they put it in like a property card or like is there an evidence technician report that would document how many photos were taken?
Jack's Beach Police, unlike JSO, doesn't do separate property cards. The property section in their supplemental reports details what property is attached to that report. So for this example, in Supplement 123, they referenced photos of clothes taken from a garage at Potomac. There are only, defense says we only have 10 photos, none of clothing. The state's response would be the photos attached to that supplement are those 10 photos. There are additional photos of clothing, although they're not, this is getting into the weeds, but there are additional photos of clothing in a folder that the evidence technician had previously provided under evidence technician photos. They're just labeled photos of clothes in the supplement, but really by clothes, they're referring to the boots, the bags, the swabs in the door. For that specific supplement. Those are the photos attached to that supplement.
Can you pause? Have these witnesses been deposed already? Like the evidence technicians and,
Some of them.
so none of these questions were answered through the deposition?
Your Honor, if I'm not mistaken, there were 3 evidence technicians that we set. I believe 1 was taken, and if I'm not mistaken, the other 2 were having medical issues or were out of country, so needed to be rescheduled.
Okay. And have not been?
They have not been.
Your Honor, I can, with regards to those outstanding evidence technicians, unfortunately, both of the remaining Jack's Beach evidence technicians were going through some serious health issues, and we just asked them to contact us when they reached a point that they were comfortable being able to have a deposition. So we're just using that, we're going to give them the necessary space that they need.
Okay.
And I think it's late in the game, Judge, but with everyone speaking, and maybe I'm just not remembering correctly, but I think when you came in, you just started the hearing. I don't think we did appearances for a clean record. Jesse Dreiser on behalf of Mr. Fernandez, Shannon
Okay.
Day, and Mr. Hill, who was just speaking. And for the times in which, on behalf of Mr. Fernandez's team, we remained silent after comments by the Gardner team, we would have spoken up if we had any disagreement or we didn't adopt those sentiments.
The evidence technicians that I guess y'all are holding on taking the deposition, are they the subject of some of these reports and I guess misunderstandings about what exists? Do you know?
I'm not really sure, Your Honor.
The
Okay.
lead evidence technician was not yet deposed. They were set December 10th. One detective was on FMLA, one detective was not served, and one detective is having a serious medical injury and has left Jacksonville Beach Police but is in contact with me. So the Detective Jarman is the lead detective. He has not yet been deposed, the lead evidence detective.
The FBI, is that Agent Blythe?
Yes, Your Honor.
Okay. I think hopefully maybe to help facilitate, if you can get answers to these questions in written response. You've listed 3 through 8, 9 through 14, you're going to hold on that this court will hear. Then, but also 15 through 17, 18 through 19. And I stopped you because and it looks like going 20.
20 I've obtained. 21 I can answer. 22 I can answer.
20 through 28, that's why I asked about the depositions of the crime scene detectives, because to me, some of these things may have been answered through deposition, but if not, obviously the defense is entitled to, whatever documents may be attached. So answer the question, I guess the state, to get an answer to these things that, let's say they exist or don't, let's say they exist, what form does the defense want it in? That evidence.com, or do you want it delivered in some other form.
I mean, to us, I would say the primary concern would be that it is provided to us in its original naming convention, which we've had difficulties with evidence.com. So that's the most important, and if the state can do that by some type of file share, then that's great. If they can and we need to provide them drives, that's great. If they want to provide us CDs, that's great. But I think the most important thing to us is that we don't lose the file structure of the naming convention as it's turned over.
Did the state ever resolve why, I guess, that delivery method results in them looking at something different?
I have not resolved that issue yet, Your Honor.
Okay. By Friday, can the state copy it over if they provide y'all a drive?
Yeah.
Copy over these items?
Right. The reports.
Yes, Your Honor. So I will, just to be specific, the state is prepared by Friday to provide items 3 through 8,
15 through 17.
15 through 17. And by provide, I mean I'm also going to answer some of these questions, but not in a formal response yet. I will send them an email with the understanding that that is not the state's final response, subject to any clarification we have at our discovery conference. 19 and 20, 21, 22, 23, 24. I need to, my paralegals indicated 25, 26, 27. I need to clarify 28, 29.
Wait. 25, 26, and 27.
Yes, ma'am.
All right.
28, I need to speak with defense counsel and with the detective in regards to what specifically they're requesting for this item. So I'm not prepared by Friday. 29, I have provided everything I got from the West Richland Police Department. I would have to reach out to them to order additional supplemental reports if they exist, so I cannot provide that by Friday. 30 and 31 I can provide. 33 I can provide. And items 32 and 34 through 42, I'm in the process of following up on. So everything in the report section that I've outlined, I can provide by Friday. Some of these I can answer by Friday, and the other ones I've referenced, I can at least let them know it's being looked into.
I'm confused. Why don't you want to put it in a disclosure? The rules say that it's a continuing obligation to disclose. So putting it in a disclosure that it was provided, I don't understand
I don't mind putting
the concern about that.
Putting in a disclosure the things I am providing. My concern becomes they're asking, some of these are questions. My concern is that I file a response in a response. So this isn't a disclosure. This is going to be a response to joint motion compel discovery. If I'm not sure that that's, at this point, for example, they said there's an animation in the slides. I believe they're referring to the FBI slides, which don't have an animation. Until I speak to them at this discovery meeting, cross-reference with ATF, my detectives, and come back and we clarify, I don't want to put in a response under Section 5, there are no animations, and then have them file some motion for sanctions attaching a different slide that I didn't know that's what they were referencing to. That's my concern. I don't want to put it in a response pleading until I'm certain of the response. These are, for the most part, items that have been either provided or listed, and there's just clarifications that need to happen between defense and state. So I'm happy to give them information or an email or the information that is known to me at this time in regards to what I believe they're referencing, but until I'm certain of it, for example, 3, 4, and 5, I'm certain I can provide those. I'm happy to respond and list those.
What about the subpoenas?
The subpoena section is going to take me more time to cross-reference because I've provided them the subpoenas I've sent. I had listed them specifically at the beginning. The issue becomes when we're sending a carrier or a financial institution or credit union a subpoena, sometimes our records are non-responsive to our date range, or they're non-responsive, or they're rejected, or they request an updated subpoena. That's going to take me a little bit more time to figure out, and that's why the discovery meeting on Thursday, presumably we'll be able to speak about a little of this, but I can at least get most of this report section done, absent the electronic data on 9 through 14 by Friday, so they at least have that before our first discovery meeting.
Mr. Cleel, this index that the state is working on, your best projection of when it will be complete? I just need an idea.
My hope would be within the next 30 days. Our attention was diverted to responding to these motions to compel, because we knew that was a priority for today's court date. And so Mr. Taylor has been going through and addressing specifically the 200-plus items listed in this response. We have begun the indexing process, and so it's our hope that we will have that concluded as quickly as possible, but we wanted to be able to address and then file a response to the defense's motion to compel discovery, going line by line and having specific responses to either providing those information or clarifying there is no record responsive to Item 15, hypothetically. And so our attention was diverted to address specifically, because that was the court's direction, defense filed a motion to compel, and we're trying to address the motion to compel specifically.
Well, this is, if I were to recap, what became apparent to this court is that there have been, which it was attached to the, I think it was a sanctions motion. There are just a number of emails going back and forth between the parties. There are, like the state is saying, you know, give us a list, and then it's a series of emails. So I wasn't telling the defense to but it's just not of record, it was my point. So there is no mechanism, and Ms. Stifler has said, well, the defense is filing sanction motions. Well, if this court is not involved in the discovery process, but for y'all saying that you're working, and I've not set any deadlines, I'm not involved, and y'all are just emailing back and forth, and then when there are issues, then what happens is there's a motion by the defense with a bunch of emails that I have no idea about. In order for me to properly manage this, like I said, the rules allow, and I should be involved in it. And I don't consider it, quote unquote, the weeds. It is, I need to be involved because y'all are not on the same page. And it's important for me to get the parties kind of on the same page, working from the same information. And so that is all I was saying. It's not documented. I didn't know that there was an agreement about DNA. That is not of record. And so now it is, I'm going to grant it. Right? Y'all didn't have any objection to that, correct? So I'm going to grant it. So this is, as far as a response, y'all do what you want. related to how you want to respond, but the response needs to conform with the rule. I am going to require that. So if you do respond that it is what it is, it needs to be categorized. It needs to per the rule, okay? Not just, I don't know, it needs to conform with the rule. The rule, I think, would solve a lot of these issues related to what the defense is objected to, which is kind of, I think y'all call it like disorganized, I can't remember what. So the rule organizes it. Any response, the defense should, from the state, should not leave them with the responsibility of what category to put it in. So the state, in whatever your response is to their order to compel, which I'm going to grant in part, and I'm going to leave part in abeyance, and I will set the other parts for a hearing to determine a time frame that is reasonable. Also, keeping in mind that this is a priority case. So it needs this, it is a state's obligation, it's a state's responsibility to categorize it for the defense so that they know what their ability is per the rules, or whether they need to seek court intervention or not. I would ask that the state, whatever you decide to do, that you comply with 3.220. That, I think, will help organize everything. And to the extent that we can, I guess, get a response prior to the meeting by Friday, that would give, I guess, about 3 to 4 working days for the defense to review it. Then hopefully that looks like about a quarter of what has been requested by the defense. I can wait, or I can intervene now, put deadlines on the response on the subpoenas, so that you all can, I guess, the state can respond whether they have it or not. And then we all come back together on May 2nd. You know, but just looking at this list, it doesn't make a whole lot of sense that, you know, some of these things are more than 2 years old, whether the state has it or not.
In terms of the subpoenas, it's not that we don't have it, it's that what we receive from the institution we subpoena is not always, for example, if I send a subpoena that asks for a specific time, date range, they've received toll records, as have I, from that institution that aren't necessarily responsive to that range. So they could send records from a different date range, or a wider date range, or a shorter date range.
Well,
It's just a matter of correlating it for them.
I will, let's put the subpoenas to the side for a moment. Let's talk about the receipt from Ruby Tuesday that was disclosed on November 15th, 2023. Like, whether y'all had that or not, to me, you should be able to respond to that, right? That doesn't take anything other than the state determining with the law enforcement or a copy of it, right?
Yes, ma'am. I said
Okay.
items 34 through 42 I should be able to provide. It's just a matter of,
So let's put the subpoenas to the side for a moment. There are a lot of them. What about the photos, videos, media? Those were disclosed in 2022.
Yes, ma'am, I'll work on providing. I know certainly some of these items are contained within the ET, at least in terms of 157, 158, are contained within the ET photo disc that was previously provided.
The DVD of the flyover, does that exist in their property room? 163.
Yes,
Are these like DVDs that just need to be copied?
most likely.
All right,
I can
Friday.
get that done.
Friday. These USB things, you're saying it's, was it somehow uploaded?
Can you give us, are you talking about?
Like 175?
Yeah, so.
Was that uploaded to something and came down? And
So that's how it's listed by the state, and our question is, we don't have a folder that's titled that, so what is it?
All right. Okay.
I mean, the old days, you'd get a disc, right, that said USB drive containing video, and you'd be like, okay, that matches with the discovery exhibit. We don't have a folder or a file name with that.
All right. The defense, y'all go get a hard drive or whatever y'all have or whatever. I don't know what, maybe y'all can talk offline about an ability to transfer these things, provide it to the state by tomorrow. Let them go out there and have somebody in the property room copying some of these things,
Yes, Judge.
all right? I'm obviously not familiar with the evidence.com. I'm not sure why y'all can't, I guess, get the disc and pay whatever fee they require, or give them hard drives or whatever y'all need to get it duplicated. I don't know what the easiest way to be. I'll let y'all talk offline about that. Like if it's they tell you disc, but these things should just be in the property room, and someone just needs to go over there and copy it. They're like, don't have, and I don't know if it's a function of it went up into that cloud and it came down and a bunch of numbers that they can't verify, but let's just copy what is in their property room by Friday.
That's fine, Your Honor. That's exactly what it is. The way I labeled it in the discovery was how it's labeled in the Jacksonville Beach Police reports. So with the supplement, it would say USB drive containing video. It's attached to a specific supplement report. I can give them that supplement report number. It's been provided through NextPoint and now evidence.com. And presumably, it's just, as Mr. Carodi said, a naming function. So I'm happy to
Let's
go
just,
to the property room and copy it.
just copy it
And then
from whatever they have. If it's a USB, give them a USB and transfer it onto whatever
Yes, ma'am.
mechanism. I'm not going to dictate that, but things that have been in the Jacksonville Beach Police Department's property room, give them whatever mechanism, whatever y'all come up with, just copy it and not upload it. So to me, that is a simple solution, and then y'all can detail it the way that you want. These interviews, I will hold that to get some type of bearing on if it does exist in recording fashion, how do they keep those?
the interviews are on discs, but the interviews have been provided. Most of what they're citing here, some of these do not have, they're just asking if there are recorded audio or visual or recorded statements of these people, and some of them there are not. The state did not record anything.
The information from the news, the state is cataloging that?
Yes, ma'am, that came out during deposition of those witnesses, and I did send all of those items via email to defense counsel previously. I will put it on a disc and attach it and reference it to this response. And I'll reference my prior email that sent those items.
And the jail calls?
The jail calls, I'm working in conjunction with Gardner's other motion filed for specific discovery.
Okay, I'll hold on that.
Yes, Your Honor. But the jail mail, items 203, 204, 205, I'm sorry, 204, 205, and 206, I can provide. I have those.
203 through 205? That's
I'm sorry,
all.
204, 205, and 206.
All right.
They have received a certain number of jail mail, and I will respond if we have additional jail mail, I will provide and confirm the number of letters.
Okay. Can y'all get the disk or hard drives by tomorrow and provide it to the state? However y'all...
Yeah, I mean, it depends what size, but generally, yes.
Okay, well, y'all talk about those numbers.
Yeah, I mean, I think
That
we're
means
talking-
nothing to me.
Yeah, I think we're talking about a relatively small amount
Right.
of data as opposed to, you know, the terabytes that exist in this case. So, yeah, I
Right.
think the answer is yes.
Okay.
You can get them a device.
Are y'all available the week of, I said May 2nd, what about April, are y'all available the week of April 21st?
Your Honor, I'm out that week.
Oh, you're out.
Yes, ma'am.
When are y'all available April 28th?
Can be available 29th to the 2nd.
What about the defense?
The 30th, the 1st, and the afternoon of the 2nd.
I am unavailable the afternoon of the 30th. the only date that works. I'm sure Mr. Hill and Day could attend. I'm
All
available
right.
all day on the 1st.
What about April 30th?
In the morning, or Ms. Day, or...
Morning? Morning?
Available that morning.
Yes, Judge.
Yes, Judge.
You know?
All right. Do you know if your witness is available?
I have a moment, Your Honor. I texted him, and I have not heard back yet.
That, so it's the 8th now. If I go to the 30th, that's essentially 30 days. Almost.
And just, so we have no intent to cross-examine the Secret Service guy on this issue. If the state wants to provide a declaration to the court, I'm just throwing options out there with regard to the witness as far as how much time he would need.
Well, the defense has asked for 30 days. If you don't
That's
object
correct.
to longer,
No, we do object, but if the
Okay.
court is going to find good cause,
well, I need to talk to him. I don't know. I'd rather do that shorter rather than later, because if I pass it all the way till then, I mean, it's an ATF agent? I thought it was somebody from JSO.
He is cross-sworn with the Secret Service and JSO CFIU.
Okay,
He works for the Jacksonville Sheriff's Office and is cross-sworn with the Secret Service.
okay. Well,
He's generally very responsive. I just need today to get in touch with him, get an idea. He might tell me otherwise. He's begun the project. He might be able to give a shorter deadline. I just haven't had a chance to speak to him since originally 2 weeks ago, giving him the device requests. I can.
all right, well, I'm going to set it April 14th for hearing a motion to be set, and then you can get with your witness, and then y'all can let me know that you got the devices, okay? And then I'll set it from there.
So no, we're not setting the 30th.
No,
Judge, did you say so we can tell you whether we got the devices?
no.
Okay.
Well, yes, like, you're going to give it to them, and they're going to give it back to you, copied.
Yes, okay.
Whatever, I don't know what method, I
I
don't
don't know. I was confused because the detective is talking about devices as in,
No.
Yes,
I'm not talking
okay.
about that. I'm talking about when you, in my mind, when you've got a lot of information, you just break it down into small, usable pieces. So
Yes, Judge.
what we can do, we're going to do. And then I'm going to check and make sure it's done. And then we're going to go on to the next issue. And then I do want an answer. The case is currently set, and I know, Mr. Dreiser, you think that it is premature. But when we all know what dates we are working towards, to me, we can spend, the remainder of this year working through these issues. We have not even gotten to the substance of this case. Y'all have not gotten to, a lot of the substance of the case. Maybe y'all have been working around, and I understand why, as complete as we can get this discovery. And I also I think it's about the time that Mr. Gano needs to file some type of report too.
so I do have an update on the court on that. We did receive a copy of a UFED report for Miss Gardner's iPhone. We have reviewed that. We found it in our review to be appropriately redacted, and we have given Mr. Gano essentially our findings, and he has indicated that he's going to move forward and provide.
I need you to document that. So,
Right, Judge.
like without objection.
Right, okay.
You see what I mean? To
Yeah,
comply with the order.
Yes, Judge.
Y'all have the time to review it.
Yep.
And then you need to say, whatever report he has provided has been reviewed, no
I
objection to
understand,
disclosure.
and I accept responsibility for that shortcoming on this occasion.
No problem. I just, we've actually made some headway.
Yes, Judge.
Which is good, okay? So,
And Mr. Gano's advised the state he's begun working on Mr. Fernandez's Google returns, so he'll.
great,
contact
we're
Mr. Dreiser.
making some headway.
Yes, Your Honor.
That's wonderful. But in order for it to move forward, Gardner has to indicate to the court that it's okay for disclosure, then I will okay the disclosure to, because you're the only one that has it. So then it goes back to the state to Fernandez. So we're moving, which is incredible news in light of where we've been in the past. So that's wonderful that at least that is moving. So as soon as you let the disclosure.
I'll file that today.
Okay. Then I will issue an order allowing disclosure per the, I think it's the second amended order that I did, okay? All right, so my thought is that you all start looking at those dates, okay? That I previously communicated, because it takes, it will take a lot of planning and coordination consistent with the order that I put into place and the factors, and that we start working toward a new date, because October is not realistic in this court's view. All right, so I'm going to give you all until we meet again to finalize what y'all think about it, okay? Do you want me to repeat the dates back? That would be proposing. Do y'all have it or no?
I'm just going through my notes. Just
The trial date, Your Honor, January 20th,
Through,
March 13th.
correct?
And what are you asking us to confer on as to whether that's realistic or that we're still available?
Look, with you all, I have to book early and often, so I want an idea of what y'all have going on in that time frame. At this point in time, I would think that because there is a trial date that y'all have blocked off that time, instead of taking time that I know that we are not going to make, I would unblock that time and move this case to a different date, is my thought. So there was in setting that, I was not anticipating that the Gardner team would be unavailable during that time frame. So what I'd like to do is reset and everybody start working towards that date, blocking those dates, giving this case the priority status that this court has now ordered on the new date. Because right now, it's April. The case is set, 6 months from now. What is it, Mr. Dreiser?
I thought I understood the new date, meaning the January to March dates. You're not suggesting that we come up with a new date.
No, that we work towards that date.
As I sit here, having listened to this entire hearing, that seems, even though it's, the next winter, spring, it seems unrealistic to me. So I was wondering if you were asking us to confer on blocking new dates, but that does not seem to be at all what you're asking, so I understand what you're saying.
Well, right now, because I have not moved, October is what I was asking y'all to block off, all the way almost to the end of the year. And so which I believe the last estimate by the state, I extended that period of time that I asked y'all to block off by, I believe, 4 weeks, to give the parties plenty of time. I don't know what any of this would look like in a trial sense. I do know just procedurally what, depending on the jury's verdicts, what the defense would be entitled to, the court's position would be as much, and when I tell you as much as I possibly can, I will have both juries working. And I'm putting it out there now that we're talking about discovery, right? That the state needs to think about, which is both juries working. That would mean that you would have to duplicate some of this evidence in both cases. So if both juries can be working / deliberating, that they are both able to work / deliberate. So as much as I can overlap them with as little downtime as I possibly can for one jury or the other, that's what needs to be done. While one case has been closed down, that jury is working, the other case will be closing down and working. And as much as, and they could share potentially physical evidence, but photographs and electronic evidence and all of those things should be duplicated so those juries don't have to be down. That they could all be working kind of simultaneously at the same time. And that's what the parties need to think about. Additionally, for scheduling, and I'm just putting it out there so that y'all can give me, y'all know what it is, I don't, right? That how you all, if it becomes necessary, how you all would choose to operate, right? Meaning that if there are, like, defendants are entitled to 2 separate penalty phases, how y'all would work with that, whether you want that or not. So those are questions when I'm scheduling that I need answers to so I can give y'all realistic timeframes, and I'm not just blocking off time that may or may not be needed, but I also need the parties to be realistic about the rights, that the presentation of some of this evidence. So those are the things that I want y'all to kind of discuss amongst yourselves about how much time you would be asking to reserve so that I can give y'all the time that you need. And I would always have like a buffer period. I'd rather reserve it and not need it than try to have people scrambling around, you know, when you have other things planned. So that's what I want y'all to discuss between now and the next time I see y'all, okay? Okay?
Yes, ma'am.
All right. April 14th, 9 a.m., hearing a motion to be set.
All right. Wow. So I think the gist of this was that kind of what we heard last time, where the state is giving the defense discovery and the defense isn't liking the way the state is giving it to them. And the judge is just trying to sort all of this out, right? So the state wanted 30 days to provide all of what came in from last time. The last hearing, the state wanted 30 days to provide all of this discovery information, and they're saying that's not realistic. Now they want 60 days. Of course, the defense wants it as fast as possible. I mean, some of the big moments, they wanted so the state wanted monthly discovery meetings, so that they didn't want to sit down and have to discuss 20 or 200 items all at once, and they've only had one. They've had one meeting so far. They had one meeting, one sit down, and they wanted to do this monthly, and they've only had one so far. So I don't know who's at fault. It seems like both are at fault, right? They were talking about PowerPoints and PDFs, and they're getting PDFs when the PowerPoint has animation, but the PDF doesn't have animation. Then there was a talk about a ATF 250-page ATF report that was found online. Judge was not happy about that. The Secret Service is involved, but they only get the extraction. And then they're squabbling about chain of custody. They call it a property card. Judge asked them if they're still using evidence.com, which I found out last time has been around since 1995. At one point, the judge asked, "What are you all doing?" She's, I guess, old school, even though she's been practicing, I think, since 98. I guess, in the early 2000s, they didn't really use evidence.com because she really didn't know. She doesn't know evidence.com. She didn't use it. Then they talk about this Detective Johns, right? So state objects to phone depositions because the defense will file motions, and the defense is saying, they're saying this is exactly the problem. We're trying to lock the state in, and they're not willing to have their lead detective come in and talk to us, so they can't be bound by that. Oh, man. Then they talked about articles of clothing in a folder, meaning not a physical folder, but a folder online. And that was done by a previous evidence technician. Judge ultimately said, "I need you to be on the same page because you don't seem to be." She gave them 4 working days, which would be today, right? She said Friday. Today's Friday for the defense to review, and it looks like they've only reviewed a quarter of what's been requested. She says she's not familiar with evidence.com. You haven't even gotten to the substance of the case. They haven't even gotten to the substance of the case. They're still squabbling about discovery, right? She's saying, okay, to me, the biggest takeaway from my standpoint as somebody who's covering this is now they're saying October is not realistic. So now they're talking about blocking off January 20th through March 13th. She's thinking it's going to be about a 4-week trial, right? She's saying, let's talk about blocking off those dates right now, meaning in January to March, because right now the case is set for 6 months, which is October. She doesn't think that October is realistic. So they're looking at now January. Wow. So the next hearing is going to be April 14th. So that's Monday. So we may cover that. We'll see if it's live. We'll follow up on this to see what more shenanigans are held. But let's see, Charmaine, they are stuck in all this admin work. Kite is like, let's move. I know, right? All right, Ken, what are you saying? Yeah, I've heard of lawyers putting confidential stuff on Scrib to share it with other lawyers. Or Scribd. Mill Stiller, everyone wants what they can't have. That's where a good judge comes in. Sinbad, I looked up and the guitars are switched. Yes. Verdict, where? What? There might be a verdict. The courtroom is filling up. I'm not sure what you're watching over there. Pammy, I'm confused as to why the one that RA is watching, Sterner. I think is that what you're talking about? Scott's watching a Sterner. The one in Michigan, I think, right? I think that's what you're talking about. Pammy, I'm confused as to why the judge has to go into so much detail. Surely these lawyers know what to expect and the protocol to put on their case. I don't know. And there is a civil case. So there was a civil case against her as well. Judge, and now this was from Wednesday. So this one was from Tuesday. Then there was another one on Wednesday, which we missed. So this is from Wednesday. Judge grants attorneys 2 weeks to submit arguments for pause in his wrongful death lawsuit. So a judge heard arguments on Wednesday morning in a wrongful death lawsuit filed by the widow of Jared. Kristen, who is the widow of Jared, filed a wrongful death lawsuit in Duval County against 3 people facing charges. So we knew that. Shanna, Mario, and Henry. So Shanna Gardner, Mario Fernandez, and Henry Tenen. The suspects' attorneys are asking the court to pause the civil case while the criminal trials are going on, as they are worried the information uncovered in the case could be used against them criminally. So Shanna and Mario's attorneys are saying pause the civil case while the criminal trials are going on, because information coming from the civil trial could come over to the criminal trial. So during the Wednesday's hearing, the judge gave Fernandez and Gardner 2 weeks to submit arguments on why the judge should pause the civil case and whether they could proceed without invoking their Fifth Amendment. The lawsuit recounts Bridegan's, I think it's Bridegan, I'll have to find out how to actually pronounce Jason's last name, included that he had just finished a date night with the twin children who he shared with Gardner, which was part of an established arrangement that took place every other Wednesday between 6:30 and 8:30, and had been going on at least 8 months before the murder, right? He dropped the twins off, then he was starting to drive home with his 2-year-old daughter, he shared with Kirsten. And then while driving home, he noticed a large car tire in the middle of the road. He got out. Once he got out, he was shot multiple times by Tenon. So Kirsten seeks at least $50,000 to recover damages incurred by the loss of her husband, survivor damages of his 4 children, medical, burial, and funeral expenses that have accumulated. Only $50,000? That seems like such a small amount. Attorneys for Bridegan have argued that Gardner and Fernandez may have made fraudulent transactions to hide their assets, which would be a big focus of the case should this go to trial. And then on the other side of it, Tenon, it's still unclear what Tenon meant when he said false testimony. So I told the state that I suspected that there may be an inmate in the jail who was influencing Mr. Tenon, and that could have been a co-defendant had gotten to him. That's just speculation trying to figure out why my client surprised me in court. Right? So right now it's scheduled for October 12th. Right now it's scheduled for October 12th. But we just heard Judge Kite. She doesn't give it much. She doesn't give it much chance of it going. Sterner, is that one? Isn't that in Michigan? Yeah. Dwayne, I think that one's in Michigan. I think we are not covering that one. Yep, Pacer. We've tried to use Pacer. Aaron has tried to uses it. I don't know, something with the finances. They were being squirrely with the money. I don't know, something like that. But you use a system called Pacer to track federal cases. That was recommended by an attorney friend, but it's only for federal cases and mostly civil. And then she was talking about 2 juries. Judge Kite was talking about 2 juries. So then there's that. It's like, what? There's 2 defendants. Wouldn't there be 1 jury? I'm so confused with this case. I want to cover it. We are covering it, but it is just, it's crazy. Linda Sterner is in Michigan. So there you go, Dwayne. If you guys want to go check that out. I'm going to probably be ending this stream. Yeah, if you want to go check out Sturmer. Go check out RA. I guess he's covering it. I checked in with him briefly a few hours ago, but all right, guys, I'm going to say goodnight. I'm going to say goodbye. Thank you for joining us. We appreciate you guys so much, and thank you so much for being with us. Monica, and then Corey Richins, and then now Shanna Gardner, and Mario Fernandez. What? All right, so thank you to Aaron. Thank you to our mods. Thank you to chat. Thank you for being with us. Have a great weekend, you guys. I am going to be off. We're going to be off. I'm not doing anything this weekend. I am going to relax. I'm going to cook. I'm going to make food. I'm going to meal prep. I'm going to hang out with the cats, with my wife. Super Ball's birthday is today. And yeah, we're just going to hang out and be. So thank you, guys. Thank you for being with us. Monday is Lori Daybell, day 5, Lori Daybell. So we will be, because Monica is done and everything's done, we're going to be switching. So we're going to be streaming, not in the morning, but we're going to be into the evening, right? So we'll be going from 1:50 p.m. Eastern till like till 8 o'clock in the evening. Then we take a break and then we do recaps with Joe. So this is the shift I was kind of talking to you guys about, I think, last week. Now that Monica is done, we truly are going to be shifting our clocks, if you will. So all that being said, please join us Monday for Lori Daybell. Looking forward to some more shenanigans from Lori with her stupid baby girl, 9th grade pipsqueak voice. Anyway, oh, yes, and Joe, yes, don't forget Joe Schmo. Yes. Joe Schmo is going to be one-on-one. Thank you for reminding me. Joe Schmo, we will definitely be there. You guys, if you guys want to hang out, we'll be watching this for sure. Joe's going to go one-on-one with Tom Evans. He was a juror for Lori's trial in Idaho. So he's going to be talking to Tom. So and Tom's written a couple books, you guys. So I'm really looking forward to that. That's going to be 5 o'clock, 5 o'clock Eastern. So check that out. Have a fantastic weekend. You guys are the best. And there's Joe's YouTube. All right. Thanks for joining us. See you guys. Have a great weekend. Maybe we'll see you Sunday at Joe's stream. And if not, we'll see you Monday at 1:50 p.m. Yeah, 1:50 in the afternoon Eastern. Have a good weekend. Have a good night. See you guys later. Bye. Yeah.